When I was first on the faculty and put on a couple conferences myself, our then Dean Hal Bruff would bring our ceremonies to open up with his warm welcome. And so it's really a special privilege to provide a welcome for an event that captures his latest project and brings some very impressive scholars here. That is the core mission of the Rothgerber Conference, which is now stewarded very well by Professor Melissa Hart, who I'll introduce in a minute. For those who don't know Ira Rothgerber, you probably don't also know that Professor Bruff is living in his house. It is a great CU law legacy, and we hope that its next occupant continues to be a steward who loves Colorado law as much as Ira Rothgerber and Hal Bruff. Ira Rothgerber is one of our great benefactors and leaders in our overall pantheon. The University of Colorado Foundation that raises money for the university as a whole, and law school in particular, was founded by Ira Rothgerber. The firm now known as Lewis Rocha Rothgerber is one of his legacies. The Rothgerber courtroom in the old law school building is still a legacy of Ira, our Rothgerber tutor program, our Rothgerber moot court finals. Ira Rothgerber is someone we take great pride in and left a lot of his legacy here at Colorado Law. Hal Bruff is someone we take great pride in. Having had him as a dean, he's the dean who hired me. I have a unique and special appreciation for his leadership. And as the current dean who's benefited from a former dean's mentorship and support, I have even more appreciation. As I think most people know, this is his last year with us on the faculty. Those of you, I know a number of students are here, have gotten to have him in the classroom. You appreciate how devoted he is. Those of us who've gotten to read his scholarship, and those of you around the country who've come here, you know what an important figure he is. And so I'm not going to introduce him, though. I'm going to introduce Melissa Hart, who has taken the Byron White Center and done great things with it. For those who don't know, this is another one of the ancient connections. Ira Rothgerber's best friend was Byron White. Byron White served on the U.S. Supreme Court, and when Ira Rothgerber was looking to leave an impact here at Colorado Law, one of the things he decided to do was set up a Byron White Center for the Study of Constitutional Law. What's great about this conference and about what Melissa has done with the center is it's really about bringing constitutional law to the public. And Hal's goal in this book was a book that everyone could read and could really think about in terms of what the Constitution means and has it. It's been handled by presidents from Washington to Obama. I think it's worth underscoring the depth of what Melissa has done and the impact she's had. The Stevens Lecture, which we've had now 4 years, and we're working on what will happen this year still, has brought Supreme Court justices to campus. The Marshall Brennan competition that she's helped develop has made a huge impact in bringing, the broad project of constitutional day and constitutional literacy to Colorado. She's been very thoughtful in working across campus, in the community. For those who want to get more involved, I know she'd love to talk to people at the reception. So with great appreciation for both Professor Melissa Hart and Professor Hal Bruff, I turn the floor over to Melissa.
Thank you all so much for being here. So first, I want to remind you that this conversation that Hal is starting for us tonight will continue tomorrow in room 301, sort of right above us, with a great group of speakers who are participating in panels from about 8:45 in the morning until about 2:15, and we would love to see any and all of you there. And now I want to introduce Hal. He asked me to give a short introduction, and I'm not going to. It's a huge honor for me to be able to introduce him, which is why I'm not going to do it slowly or briefly. I've known him for almost 16 years. Like Phil, I was hired by Hal. He was the dean when I interviewed here, and he's been a mentor and a friend ever since. You have his resume in your program or his bio, so I'm not going to spend a lot of time going over that. Just to say he's a Colorado native who went back east for college at Williams College and to law school at Harvard. He has served on the faculty at Arizona State University, the University of Texas, and George Washington University. And I think we here are just incredibly blessed and lucky that he came home to spend the last 2 decades of his academic career at CU Law School. I think how lucky we are all the time. Hal's intellect and expertise are an important part of his extraordinary career, but his career has included not only what he wrote, but also much more. So I want to spend a few minutes sharing some of the things that his students, current and former, and his colleagues have said to me about him as I prepared to give this introduction tonight. One student wrote to me, "From the moment students walk into Professor Bruff's classroom, it becomes immediately apparent how deeply he cares about each and every student. He makes a concerted effort to know all of his students' names and backgrounds within the first weeks of class. The warm and welcoming atmosphere he creates is not only conducive to learning complex legal issues, but encourages students to reach out to him for career and personal advice. Although he is one of the most accomplished professors at the school, he is undoubtedly the most approachable professor. Whether you are speaking to him about the law, government, or Mustard's Last Stand, he is always encouraging and positive." The themes in these remarks were echoed in the many others that I received from students, some of whom I reached out to and some of whom I didn't know would have a connection with Professor Bruff, and other students put me in touch with him, put them in touch with me. All of his current and former students note his compassion in teaching really sensitive and complex topics. As one student put it, "I was most struck about how he seemed to genuinely care about students' opinions and how he solicited those opinions and welcomed them in a way that created an incredibly comfortable environment. I loved that such a renowned constitutional scholar seemed so genuinely interested in what a bunch of 1Ls thought." While we are here tonight to learn from Hal about constitutional law, I was reminded by one of his former students about his expertise in another area. She wrote, "Professor Bruff stood out to me from the very first days of law school. My 1L year was the year Hal agreed to teach every single 1L leg reg in 2 huge sections." That's actually a true thing. Not only that, he learned and still remembers all of our names. To me, that shows an extraordinary level of dedication to CU. Also, she adds, "He let me off from being cold called one day when I was delusional on cough medicine." I want to close this introduction by sharing 2 last short comments, one from a colleague and another from a student. The colleague said that Hal has a quality about him that makes me want to be better than I ever thought I could be. I imagine that many of us in the room feel the same way. Hal inspires people to be thoughtful people, critical thinkers, and engaged community members. The final comment I want to share before turning the floor to Hal is from a student who wrote that Hal can turn the most boring, dry material into story time material. The legal world is definitely more magical for having him in it. We are all now lucky to experience a little of that magic tonight.
Lovely. Is the mic mic'd? The mic is mic'd. That sets such a lovely atmosphere. I think I shouldn't say a word more. I can only spoil it. But I'll call on Ira Rothgerber's spirit to carry me, and along we'll go. Standing here talking to you, I'm held upright by support from all sides. So I want to say a few words of thanks of my own before beginning the talk. First, I must mention the main prop I have in this life, the incomparable Sherry Bruff, sine qua non, as we lawyers would say. And I thank our gracious and gifted Dean and Director of the White Center for those really heartwarming remarks at the start. And I thank you both for being gluttons for punishment in organizing not one but 2 Rothgerber conferences this year, this one for me now, the one for Bob Nagel in the spring. That's a lot to do. I thank as well the many people on the Dean's Office staff and the White Center staff who've helped our staff, our students, push the wagon in lots of ways, and they don't get necessarily enough credit for it. I want to give special note to my magical faculty assistant, Diana Avalos, who is trying to hide in the back at the moment. Then the Law Review will, of course, publish the proceedings, the papers of the conference. They have had an all-hands-on-deck effort for several days now, getting the speakers here, supporting everything. They will then get to read everything that's written 4 times, or however many. So thank you, all of you. The speakers. 9 speakers. They have come from such exotic and faraway locations as South Australia and Northern Manhattan, Nashville, all over the place. You honor me by coming deeply. Past the speakers, there is the audience. One needs an audience if one shall speak. Most of my best friends from the community are ranged out here. Thank you for coming. Colleagues from the faculty, honored by you. And of course, students. So students, I want to tell you something. I'm not going to read something to you. I'm going to teach it more or less the way I do a class. And I simply tell you now that if you think you've had one too many already, you're sunk. Okay? It's too late to slip away. Okay, let's get to the talk. There's the book. A book that I hope will begin a conversation that should begin tomorrow morning with our panels. The panels look just terrific, and will continue almost indefinitely. The first question that an author should answer, especially for a book like this, is simple. Why does anyone need to write yet another book about the American presidency? Well, I'll give you my answer to that. Of course, part of it is just, well, I want to say what I wanted to say. But really what drove it is the perception that I formed years ago, 40 years of teaching and writing about separation of powers and presidential power, that at least for separation of powers, the most important single interpreter of the Constitution is the president. It's not the Chief Justice. It's not even Anthony Kennedy, who thinks he is the most important interpreter of the United States Constitution. Now, for some Bill of Rights matters and others, one of those 2 last gentlemen may be the most important interpreter, but for presidential power and a lot of separation of powers, it's the president, and the president has a hand in interpretation, of course, of all the rest of the Constitution, too. In thinking about presidential interpretation, what struck me, and I'm thinking now, Peter Shane, back to our days in the Justice Department as kid lawyers, that's a long time ago, of the fact that presidential interpretations are lawyered to a fare thee well. We used to do that, yes, thick and turgid memos explaining the law that would bear on some presidential interpretation. But at the end of the day, all of that really falls away. Barack Obama, before he was president, put it perfectly. The interpretive decision by a president is, at the end of the day, a decision by one individual. That's what makes that style of interpretation fluid, possibly consistent as one individual follows another, speedy, and dangerous. Martin Flaherty, among our speakers, wrote a great article years ago titled "The Most Dangerous Branch" about the executive. Of course that's right. Of course that's right. So, there you are, the 25th mile of the marathon, the last mile. What's in the interpreter's heart? What do we mean by heart? Let's unpack it. The ingredients of interpretation, there's a little list here on the slide of things that I think go into the interpreter's mind, whether it be the president or actually this is true of other interpreters as well, judges and others. That is, the person's character and experience. Of course, we interpret out of our personality, our experience. Political values, the president's response to the incentives that the office creates, reaction to the pressure of events, and I think maybe most interestingly to me, the presence of precedents by predecessors. I'll come back to that. The title of the book comes from something that George Washington said the first months of his presidency. He said, "I'm standing on untrodden ground. Everything I do will be cast into precedent. I have to be very careful." He was, and what he understood is that as presidents have done things interpreting the Constitution, they've formed a record of precedent that is much like the common law. For all the lawyers and law students in the room, it always strikes me as very like the accretion of precedent in the common law, where things go from informal practice to eventually threads of law. So, accumulation of precedent over the many years. Then the question, I've said that interpretation is personal. You can tell from the factors that bear on it that it can be wide-ranging. What constrains it? The Supreme Court has decided, I count about 25 main cases, Peter, in our case book on this that have some constraint on what presidents do. The Supreme Court is usually not the main constraint. Sometimes, not usually. What is the president's anticipation of what the reaction in the country is going to be. The reaction from Congress, the reaction from we the people. So what really matters here is what happens once a decision is made, but as anticipated by a president before it is made. When I say there is a need for acceptance by Congress and the people, please notice what that implies. It implies that Congress can have the last word. Most of us, I think all of us, speakers on the panel, think it's very important for Congress to have the last word on most exercises of presidential power. Where there is exclusive presidential power, there is great risk of arbitrary government or of loss of control entirely in the worst scenarios. So interpretation then is really a reciprocal process between presidents and all of us. I think Ben Franklin captured it perfectly in the quote on the slide. What had the Constitutional Convention made? A republic if you can keep it. And keeping it is for us to do today and all days. That reciprocal duty is still there, and what presidents we get is largely a product of what presidents we will tolerate. Very importantly, keeping our presidents accountable depends on the information we have about what they're doing. Otherwise, we can't know. As I looked at the work product of our 9 panelists, I thought to myself, you know, the main thread of commonality that I see there is an emphasis on accountability. Very often on information, terrific recent work that I'll mention as I go along about that. So the question really is then, how do we pursue accountability? And I think that will be the theme, the thread, tomorrow morning and afternoon. Okay. Accountability for what? Here's where I turn to the advertised theme, having introduced the book. The faithful execution duty is very often called the main standard we have for judging presidents. And what I want you to notice, please, is that it's not single, it's divided in 2. First, there is the oath every president takes at the moment of taking office. In the oath, the president swears to faithfully execute the office of the presidency and to defend the Constitution. Then further along in Article 2 is the injunction for the president to take care that the laws be faithfully executed. That means by subordinates. Others are going to do that. So the president has a two-part duty. Do your own job and make sure your subordinates do theirs. And thinking of the oath a little further, presidents talk about it. Lincoln talked about it all the time. He said in his first inaugural, it was, quote, registered in heaven. It really gets their attention. Imagine you take the oath in front of everyone in the world on the east front of the Capitol, or in a time of personal trauma when you've just been notified that the president is dead and you are the new president. So it sticks. Okay. The faithful execution duty, or duties, however you want to say it, faithfully execute the office, the laws. What does that mean? I'll address 5 questions, and happily for the audience, I'll even explain them. In whose hands? Who, whom? With whose help? How? And the most irritating question lawyers ask on a daily basis, so what? Okay. In whose hands? First question. Here we look at the 5 ingredients of decision again, in the context of their exercise by presidents, as opposed to most anyone who would interpret something. Character drives interpretation. As I was looking at the behavior of all of our presidents, it became clear the extent to which the few weak people who've inhabited the office, James Buchanan and Warren Harding probably win that prize jointly, could not conceivably have followed a strong interpretation of presidential powers. They didn't have it in them. They rose to no duties that I can describe. Weak human beings are not going to find strong powers. The relatively strong presidents, the more granitic ones, Washington, Lincoln, etc., uniformly take a strong view of their powers. There are people in between. I think of, for example, Taft, who was very lawyerly, I think maybe a little too much in some ways I describe in the book. He lacked a little moral spark to the office. So there's a range there, and I think that aggressiveness of interpretation follows personal character quite well. So as you pick your next president, do be thinking about that. Secondly, political values. I mean by that political values in the broadest sense. Almost every president who we learn and talk about has a vision of the nation. And these presidents have situated their view of the Constitution within that vision of the nation. So Jefferson, for example, seeing his grand vision of an agrarian, decentralized republic, saw a federal government that would fit that. Weak, not doing much. Abraham Lincoln, seeing a nation that could both hold itself together in the Civil War and begin the march toward international greatness, saw a federal government that could hold the Union together. So the president's sense for broadest political values reads into the Constitution. And one thing I'm saying is presidents don't tend to approach the Constitution and its particularities like a land conveyancer would. They're not fly-specking a deed. They're looking at a constituent document. All of you students and faculty know Marshall's famous phrase that it's a constitution. We are expounding, they emphatically approach it in that way. The other ingredients, the incentives in the presidency, clearly these generally favor strong interpretations. The reason is fairly simple. The second a president is in office, he discovers that everybody is trying to prevent, or some people are trying to prevent everything he's trying to do. You get pushback on everything. You've got to rally your friends, and you also start thinking, I'd better not make minimalist claims of my powers. They will steamroll me. The reason presidents think that is if they take minimalist views, they will be steamrolled. We have forgotten the Whigs. a man named Michael Gerhardt wrote a wonderful book called The Forgotten President. The Whigs get all sorts of chapters, so pity the poor Whigs. They had a theory of the presidency that should be very weak and administrative and not very discretionary. Whig presidents got in, they all died immediately, pretty much. But when they did get in, they didn't behave according to Whig orthodoxy. They couldn't. They started doing things that didn't sound like the party platform. Didn't help, the Whigs are still gone. Fate intervenes. One of my favorite things is presidents who have come to office saying, Bill Clinton, I'm going to be a domestic policy president. Then he had various foreign policy crises thrust upon him. Or Richard Nixon, who said that he was going to be a foreign policy president. Domestic policy was about building outhouses in Peoria. Well, he had some domestic difficulties, as you may recall. Okay. So you have to solve the problems of the day, and interpretation is always in that context. Then, I think what interested me so much in writing the book, presidents are very interested in what their predecessors have done. You notice, of course, we all see this in our daily lives, the clubby behavior that ex-presidents display, hugging each other, and they all get along just famously. I think that is playing here in the sense that presidents know that prior presidents are the only people who have faced that responsibility. They're the only ones who have felt the weight. And so they want to know what they did and why, and they will cite it. Now, some of the citation is for the purest of political reasons. Every president in doing something wants to be able to say, my predecessors of both parties, they'll always say, have done this, therefore I get to do it. So there is that search, but I also think it's genuine. They really do display a lot of interest in what prior presidents have done. And in the end, this tends to move them toward paths of well-trodden ground. It bumps them in that direction. If you're heading onto untrodden ground, new issues, you're just feeling more isolated. If you're going down well-trodden paths, you feel safer. So stability promotes acceptability, if you can cite lots of things. So you sum all this up in some way, and I think you've discovered the key to what Barack Obama said he meant by the interpreter's heart. All these things. And of course, the components vary in their effect. Question 2. Whom? Vladimir Lenin had a charming view of politics, did he not? He said the question of the 20th century was going to be, who is going to do what? To whom? I think that's the story of the 20th century, folks, as I look back at it. A lot of bad actors are doing a lot of things to a lot of people. So Lenin was frank about that. American presidents are not. They will repeatedly place their hand over their heart and promise to be a tribune of the entire people of the United States. You should chuckle indulgently when they say that. It's not how they behave. They favor some groups, they disfavor others. How do you tell which ones? Well, the electoral coalition that they rely upon, of course, will be a general guide to that. They also have to do some things that will appease powerful groups that they have to find some way to deal with. I give examples on the slide from the labor management field, Gilded Age presidents helping the corporations bust unions, Teddy Roosevelt, who always thought he knew what was best for everyone, deciding to give everyone a square deal. I guess he was doing the angles himself. So he brought workers into the mix. He was mediating between management and labor. By the time of Harry Truman, Harry seized the steel mills. Why did he do it? To give workers a raise without letting the company raise prices. That's really what was going on. And since the Supreme Court happened to know that, they struck down the order as against a statute, and that was actually the correct outcome. So there's that. Presidents are going to have their friends and folks they disfavor. Reaction I had to that right away was, okay, what goes around comes around, so maybe over the years, we kind of all do okay. When one of our folks is in, we're up, and the other party, maybe we're down. There's a lot of that, but also there's a couple of groups that are consistent losers. The downtrodden, pity the poor. I count really FDR and LBJ as the only presidents to really put political capital on the line to help them. Some presidents, this is very unattractive, I think, as I went through it. Some presidents have said that the federal government simply has no power to help the poor. That is no part of the general welfare that the Constitution allows taxing and spending for. The correct answer, I think, is why not, and how do you jibe that with the oath? But anyway, a very sad ignoring, I think, of those at the bottom of the pile. The other is dissenters. I list on the slide some of the famous periods of presidential harassment of dissenters. It has tended to take two forms. One is, ever since Franklin Roosevelt, and dominant now, has been presidential surveillance. Roosevelt claimed an inherent presidential power to surveil, to detect threats against the United States. Every later president has articulated some form of this. So the spying on civilian scandals of the 1970s, all the rest of it stems from that. Some presidents have simply tried to suppress dissent. The worst record there is clearly Woodrow Wilson after World War I. Lots of unjustified suppression and prosecution. Lincoln did some things that were pretty harsh during the Civil War, but most of it was arrests and not prosecutions. He shut down a couple of newspapers, things like that. His record actually, I think, was far milder in suppressing dissent than Wilson's in a situation of much greater urgency. And what strikes me in looking at our history is this. If a president has to balance civil liberties against national security, security is going to win. Security is going to win. They always think, first I have to keep the ship afloat, and I'll just worry later about rights. We have to have security. I am sworn to defend the Constitution. By that I mean the nation. Security trumps. Okay. Whom? Third, with whose help? This really is the second part of the president's duty, the faithful execution clause, the take care clause, as so often called. Notice here, and this is something that Kevin Stack has developed very nicely in an article about the rule of law, that the president's duty regarding his subordinates is not to simply take decisions away from them and make them himself. Instead, he supervises what they do. Kevin has emphasized that the duties have to stay in the hands where statutes place them. I will give you an example soon about why I think that's particularly important. So it is, at its heart, then, a supervisory relationship. Okay, what's the president supposed to do with regard to subordinates? Three main things. You pick the subordinates, you supervise them in ways that are appropriate, and if they fail, you fire them. Simple enough. He's the boss. Okay. The real challenges: selection, supervision, removal. It may surprise you that presidents very often just hate making nominations. The famous line that I put on the slide there, I've seen it attributed to Jefferson, Polk, Lincoln, others. When you select anybody for a nomination, you create one ingrate and 20 enemies. Most people who've managed anything have learned that, actually. So it's no fun. In fact, Polk hated it so much that when at the end of his one term of office he went home to Tennessee and died within about a couple of months, I think the headline should have been, "Patronage Kills Polk." He just hated it. And he had the interesting reaction to it. He said, patronage means I can't control the executive branch. I can't pick the people I prefer. I am forever having to please this party magnate or that one. So I don't have kind of my first order choices in place. Throughout our history, this has meant that the president's nomination power is politically deeply compromised. When the Senate has the power of confirmation, of course, there is a structural constitutional qualification on the power. So I think of the president's nomination, his selection opportunities as a kind of a second best set of choices. Now notice that there is some countervailing benefit here in the following sense. If presidents could simply pick whomever they wanted, and parliamentary systems pretend their PMs can pick whoever they want, but my Australian visitors know that the party has some things to say about that. But if they could pick whomever they wanted, and we had a monolithic executive branch, maybe they would all sing the same tune. Presidents like to try to get them all to sing the same tune, and I have never seen it happen. That means there's an accountability mechanism there. Splits, differences within the executive tend to bring scandal, controversy forward through leaks, all the ways we see it. So a somewhat fragmented executive branch has its advantages for finding out what the little rascals are doing. Okay. Then, and this will be a generalization, presidents can't take really serious attention to every nomination that lies in their gift. So where I see them really focusing mostly is on the things that count the most to them. There are exceptions to this, but in general, I think in selection of personnel, presidents are most interested in the three things on this slide. One is what I call the constitutional cabinet. It's the four original functions of the executive branch: state, defense, treasury, and what is now justice. Because those are the parts of the executive branch that most directly serve the president's constitutional powers: war, foreign policy, spending, law. Lots of attention there. Presidents are not casual about who the Attorney General is going to be. Then presidents try to manage the institutional bureaucracy that dates from FDR. So they must manage the managers. Well, they have a chief of staff to manage the managers of the managers very often. Think about how many people one person can really meaningfully supervise. The president's West Wing crowd is a few dozen people. There are other people across the street in the Office of Management and Budget, the cabinet, and so on. Pretty speedily, you get to quite a few people. So presidents want their managers to manage the executive branch. We're to remove, then. Office of Management and Budget is the main institution for that. Then the military leadership. Presidents are intensely interested in whom to pick as chair of the Joint Chiefs of Staff. And the greatest threats, I think, to our republic in American history have come from two supreme egotistic generals, McClellan and MacArthur, when the lines of civilian command were put most under stress. That obviously matters. Presidents know it. What about firing people? Do you see why, if you don't much like nominating new ones, you don't much want to fire the old ones? You just get to go through the whole thing again, plus you may well have an angry Senate. We don't like angry Senates if we're presidents. Oh, the ink. Oh, the trees. Pity the trees that have been slain over the issue of presidential removal of executive officers. Yeah, I've killed a few myself. I think I have to plead guilty on this. It doesn't matter very much. The law of it doesn't matter very much. Why? Because for the people the president most wants to control, he has plenary removal power. It's the folks in those three categories I mentioned. The immediate cabinet, of course the whole cabinet, his aides, and senior military officers. For the independent agencies, the Federal Reserve Board, SEC, FCC, all the alphabet agencies, removal is restricted by statute. That keeps presidents from going anywhere near them politically. They don't try to remove those commissioners because they don't care that much about what those agencies do most of the time, or they fear severe congressional pushback if they were to do something like removing a chair of the Federal Reserve. If a president did that, world markets would, yes, you know what they would do. Okay. So, removal, However, here comes removal and the rule of law. It's a point about it that I think isn't generally noted in the removal debate. I think it's what matters about it. And it bears on the point that I was associating with Kevin Stack just a little bit ago. The story on the slide is about Jackson's attempt to destroy the Bank of the United States in the 1830s. One of the things he wanted to do was take the federal funds out of the Bank of the U.S. His Treasury Secretary had the statutory power to do that. And so Jackson said, go do that. The Secretary said, sir, I can't. It would be illegal. The statute wants me to keep these funds in the bank if they are safe there. They are. And it won't let me take them out if they'd be unsafe where they would be put, which was state banks. So the Treasury Secretary said no. Then an extraordinary thing happened. Jackson was probably the most dominating personality ever to sit in the Oval Office. I am not discounting Lyndon Johnson when I say this. He simply dominated everybody around him. He didn't do what you would think he would have done, which would be chase the secretary out of town physically. Instead, he engaged in a long litigation with him through memoranda to the cabinet, back and forth. He was very delicate. It was his instinct that he couldn't simply take the decision away from the secretary. He had to try to talk the secretary into it. Finally, he couldn't get it done. He removed the secretary. And then, of course, what happened is he needed another one to remove the funds from the bank. So he had, and the Senate simply exploded. The Senate was not going to confirm anybody for the post until Jackson desisted. Being Jackson, he did not desist. He never retreated. So he eventually worked through another nominee, Roger Taney. I don't know what happened to him. Anyway, what it shows you is this. When we leave statutory decisions in the hands of the people who are assigned them, some very important things happen. One of them is this. Those of you who are in administrative law have been seeing this these last months. A vast realm of American administrative law controls subordinate decisions. They have to be justified under the statute, facts, very elaborate. More important than that, perhaps, and presidential decisions are reviewed much more weekly. More important from that, I think, is the assignment of personal responsibility. That is, if you're given responsibility to do something, it's on you. It's your name on whatever the action is. And you know that your reputation, maybe liability, whatever, rests on you. You'll be careful. A president talking to subordinate officers is not necessarily careful at all. The president simply may be saying to a subordinate, Jackson could have said to the Secretary of the Treasury, hey, Bill, let's just get the funds out of the bank, will you? Just get it done. The secretary goes away thinking, oh, now what do I tell him? The point is, the president doesn't have to think this through because the president isn't directly responsible for it. He's responsible for his office, and he's supposed to be cabining the secretary as well. But modern forces of law then coalesce at the subordinate officer level. And one thing that means is that if the president is held to a supervisory role, we can accommodate that to the fact that the president has great practical power and to the need to maintain the rule of law in what agencies do. So it all, I think, promotes accountability, promotes the rule of law. Okay. How? How is it done? Given the size of the bureaucracy, much of it is done by what are called generically executive orders, commands to the bureaucracy in the general sense of the term. Presidents have issued these since Washington. The modern framework for assessing their legality comes, as all law students know, from Robert Jackson's great opinion in the Steele seizure case, where he put out a three-part analysis that everybody still uses. If a statute authorizes what the president is doing, the president's going to win. If a statute forbids it, then you can let the president prevail only if his constitutional power disables Congress. The courts are very unwilling to come to that conclusion. In the middle is the fun part. Jackson called it a twilight zone. I want to call it the combat zone, because here, no statute either clearly blesses it nor forbids it. And so get the lawyers. The lawyers come out, look at implied statutory authority, fend off implied restrictions, and bless what's going on. The President's record in Category 1 cases of implied authority is very strong. In Category 3 cases of congressional rejection is weak. And in the twilight zone, presidents usually win. They do very well in the twilight zone. Okay. Here's a demonstration of the point I was making about accretion of precedent from the very start of the talk on. Look at the programs that are involved here. What you'll see is that presidents have been building on their predecessors in ways that increasingly seem to them are safe. Teddy Roosevelt started creating national monuments to save precious lands. He even set the Grand Canyon aside. Presidents are still doing that. Our own Charles Wilkinson helped with designation of the Grand Staircase National Monument. And even as we speak, he is elsewhere working on yet another monument designation by a president, all of them building on Teddy's legacy. Civil rights order, Truman's gutsy desegregation of the military immediately after World War II. Those have continued under presidents of both parties, promoting equality, even affirmative action, in federal programs that the president controls, contracting, employment, and so on. And then the regulatory management orders, the delights and mysteries of cost-benefit analysis by which presidents supervise the regulatory bureaucracy. Below them, what strikes me is the original important order, which Peter and I worked on in 1981, is kind of still in place. It must have been a classic, Peter. It's been changed on the margin in some places, but the basic structure is still recognizable all these years later. And presidents even use the executive order of their predecessor. They don't even do their own and name it for themselves all the time. So very durable, very durable. Law enforcement priorities, a central part of the faithful execution duty of any executive officer at any level. Here's the problem. What does faithful execution consist of when we get to enforcement discretion? Unfortunately, we can't simply say more is always better than less. I give the homely example on the slide of a city police chief who decides one day to simply enforce the traffic laws as written. This means you tell each officer to ticket every violation he or she sees. The system will crash. Now the Posens, this is David and his wife, have written, that's why it says Posens, David, have written a terrific article called Uncivil Obedience, in which they make the point that executive officers who really get angry will very often simply go by the book. This will bring the unit to a halt in no time, flat, because you have to have discretion in enforcement. In fact, the correct amount of faithful execution may be 0. That's Thomas Jefferson coming into office and saying, I won't enforce the Sedition Act of 1798. It's unconstitutional. He was right. We all think that nowadays. That's the right thing to have done. So it's somewhere from 0 to 100, but it's never going to reach 100. We never have the people. We never have the money. Okay. So the question is, how much enforcement? What kinds? And here comes Vladimir Lenin again. Against whom? Okay. The immigration order. Very interesting. And we'll talk about it tomorrow, I am sure. Obama's immigration order, there's the situation that he confronted. 11.3 million undocumented aliens in the country, with funding to deport as many as 400,000 per year. Do the math. Even with nobody else coming over, you're never going to get to the bottom of the pile. So what has to happen is presidents have got to figure out who's first, who's last. Do all of you see that's an intrinsic part of the faithful execution duty here? Obama's order, whatever you think of it, has one major virtue. It's visible. He said, this is what I'm going to do. These are my priorities. Congress can get mad, and they did. The courts can actually review it, and they are. The alternative, one alternative, is simply for the president to say a few quiet words to the Chief of Homeland Security. You know, Jay, tell you what, let's send the crooks out first and leave the students alone, okay? Don't talk about it. Just do that. Very hard for any of us to tell what's going on out there, all these people. Very hard for Congress, the courts, or any of us to review it. Peter and I both think the order is within legal boundaries. It has some implied statutory support in some places. But fundamentally, I think it's a decent interpretation of what the faithful execution duty requires in this situation, with part of the situation, very importantly, being that Congress is locked. The ordinary result for a president in this kind of situation would have been to go to Congress and say, make up your minds, give me a lot more money, give me some instructions, who's first, who's last. Congress, of course, can't move anything with regard to immigration, so the president has to do what David Posen calls presidential self-help. Peter Shane calls it the president's statutory stretch. He's stretching, but you know, I think the controversy over it is so much about the scale of it. The scale of it is huge. It affects as many as 4 million people. But the stakes in a lot of other executive discretionary decisions are gigantic as well. We can talk about that in Q&A. So what? Looking at it all together, what are the effects on the government, on us? One thing that always struck me is that executive orders are much more vulnerable politically than legally. If you've got the right folks in the Department of Justice and they lawyer the thing up, it should get through, and they usually do. More important, and this is part of self-help, a president has the immense power of the veto, so that if an order is legal enough under today's constellation of statutes, a president can rest on that, and if Congress tries to change by legislation, he'll veto it. Overrides are very difficult, very rare, so he can maintain the status quo. And here's a bottom line. I see the faithful execution discretion as a really critical grease for our clunky old machine of government. It keeps it running in times of, as now, gridlock between the branches. It provides a little bit of buffer between two separated branches. And I think our two Australian friends will say tomorrow when they talk about parliamentary systems, there's just not so severe a need, Gabrielle and Adam, for this kind of discretion, worrisome as it sometimes is, in a fully functioning parliamentary system. Although if you have a cranky Senate, as does Australia, you might find some occasion for it. Okay, getting near the end. Some of you students in the room have heard this from me. I think the really critical challenge for our country, for the generation now rising through law school, for the 21st century in controlling our presidents, is the national security bureaucracy. Since World War II, it has grown. It is massive. It is secret. It wants to look at us. It doesn't want us to look at it. And here's the question that most dismays me. Suppose you were to ask me, all right, what does President Obama know about what the national security bureaucracy is doing? My answer is, I don't know. You don't know. Intrepid reporters don't know. Edward Snowden found out a few things and cut them out. It's beyond my capacity of belief to think that one human being, like whoever is the sitting president, can easily or effectively monitor and hold to law this gigantic, partly privatized security bureaucracy. It is going to be with us. This is the accountability issue for our age, I think. I am very happy with recent work done by our panelists on this. Heidi Rosser's award-winning book on reclaiming accountability works on this. She'll talk about it tomorrow. Peter Shane's and Madison's Nightmare, that's right, the nightmare is modern executive power, is an earlier attempt at this. Kathleen Clark's fine article on intelligence disclosures is another. We, the people, have to take it up too, and for a start on that, we simply must go to the panels tomorrow. Okay. Bottom lines. How do we evaluate presidential actions? Some simple criteria and one profound one. First, did it work? The Emancipation Proclamation worked. Increased the flows of runaways, undermined the Confederacy. So just did it work in politics and in fact? Second, did it stick? The executive order programs that go on from president to president have durability. That's stuck. Third, I hope this is a criterion. What do people like law school and history professors think of it all? Do they give the order good grades or bad grades? Here, some orders in history have such a bad odor, the Japanese internment, Jackson's Indian removal, it's not going to happen again. And part of that, I think, is the weight of historical judgment. Fourth, do later presidents like this precedent? Does it become part of their menu of choices? And again, the historical reputation of orders will say a lot about that. Finally, statesmanship. The most elusive criterion of all, the one we care most about. Hank Chambers, who will be speaking tomorrow, wrote a terrific article saying that the Emancipation Proclamation can be justified not just under Lincoln's military orders and powers, but as an exercise of the faithful execution duty. I think that's just exactly right. And at bottom, here's what we hope for, that when a president interprets the Constitution, especially in terms of crisis, the view of the Constitution can transform the nation and its Constitution and lead us on the path to a better future. That brings me to, I'm back. That brought me clear out of the program is what it did. Let's do, this will do it. Back to this, the picture. Here's why I chose this picture for the cover. It portrays what I call the best day in the history of the presidency. Abraham Lincoln is walking along. He's on untrodden ground, of course. He's holding the hand of his son, Tad. In the back is a little squad of soldiers and sailors. Well, after all, he's walking down the street in Richmond, Virginia in April 1865, and Union armies have just taken it. And on all sides, freed slaves are calling out to him, reaching out to him. He has transformed the nation, redeemed its originating promises, and set us on a better path toward the future. That's my greatest hope for any president, especially in transformative times. I think it should be our hope. I don't know how often realized, but there you are. Okay, that's my story. Comments and questions. I would like to start with a student, of course. Annie, you've got the mic. A student. Casey.
Is that on? All right. Thank you, Professor Bruff. That was great. I was wondering, in your studies, you really emphasize how personal it is to each president. Have you noticed a theme emerging between those who were trained as lawyers and those who weren't?
I talk about it a little bit in the book, and it's interesting. The root question, Casey, would be, do lawyer presidents do better at this? Well, some lawyer presidents were trained in the law and escaped at the first chance they had. Woodrow Wilson, Franklin Roosevelt, Bill Clinton, sort of, he didn't do much practicing. It's because presidents don't think like lawyers very much. Taft did. He was very lawyer-like. So maybe there's some effect there, but lawyer presidents have included Richard Nixon. So the forces, I notice I don't need to elaborate that point very much. The forces that drive presidents hither and thither from their own internal demons or angels or whatever don't seem to me to depend very much on the lawyering of it. It's the large questions of the fate of the nation and this stuff. It's their political side that drives the big issues. So law training, on the margin, interesting. Next. Nat.
So I was thinking that since they're going to rise in to hold him politically accountable, he can get the people on his side, kind of pressuring Congress back. Has there been a kind of growth in the interpretive, I guess, indulgence of presidents since the advent of radio, television, the internet?
I don't know that that is true. In fact, presidents have reached toward the people, really starting with Jefferson, who found ways to do it. They would do it, for example, Lincoln did it through his open letters that were then in the papers. So the media gave a megaphone effect, of course, once they rose. But what really had to happen was presidents started to have the habit of appealing directly to the people. Jackson was the first to do that systematically. Wilson did it all the time at the eve of the age of radio. And the main effect of the media seems to have been, I think, to accelerate what's typically called the continuous political campaign, in which we spend 2 days governing and the rest of the time campaigning for it. That seems to me the most powerful difference. Peter Shane. Peter ought to have his moment here.
Hal, so
Did I do that?
I've never had this spotlight.
I would never,
cast on me
Peter, I
quite
would
that
never.
way.
Anyway.
So, one Burkean thread I suppose you and I share is we're not terribly enthusiastic about the idea of huge institutional changes in the Constitution
Right.
as a cure for our ills. But one of your first mentors, Sandy Levinson, is basically he thinks we're doomed under current political circumstances by the way things are set up. In your book, you say, presidents have managed to walk a fairly stable path. And I share that instinct, but I'm reminded of the person who defined optimism as what the person falling from the 15th-story window says as he passes the 12th story. So far, so good.
Yeah.
What do you think? Have the circumstances changed so much that we really have to worry about the possibility of maintaining stability under the current distribution of political forces?
I think we do, both in terms of the general political dysfunction that has simply stopped Congress cold, and in terms of what I was saying about the massive security bureaucracy. With a dysfunctional Congress, they are that much less able to help out, to control in some ways that receive bipartisan support. The hard thing to do, not for Sandy, but for most of us, is to figure out what constitutional change might make things better. The ones I tend to favor are elsewhere, for example, a term for Supreme Court justices, and so on. But my instinct, you have it right, is to keep it toward the margin. I liked what Grant Gilmore said years ago. He said, legal training makes you conservative about large change, because what you learn is that reform doesn't get things much better necessarily, and that there's something to be said for however things are. So I'm pretty cautious on this. And there's not a little addendum at the end saying, if only the following 4 constitutional amendments rearranging Article 2 were to be enacted, we'd be a happy nation. I think you can tell that I think there's a lot of momentum behind the tanker, and it's hard to change direction and almost impossible to amend the Constitution. Next. Peter. From the community, we're kind of covering all the bases.
A non-lawyer. What would you say, or can you say as the general principle, what the relative weight of the first 25 miles and the last 1.2 are?
Way back in the day, I ran 10 marathons. Got through all of them. I would say that last mile and 385 yards, 384, 386. It's very central to the experience. Very central to the experience. And I think the thrust of the book is you know, presidents and their opponents can lawyer every bit of this up, down, and sideways. The presidential legal bureaucracy is composed of very bright people. We worked at the Office of Legal Counsel at a time when people now famous were our young colleagues. So these are, you can find argumentation for most anything. And the issues of professional responsibility are severe. Will you simply say yes to anything a president wants to propose? Robert Jackson once famously said, "What I can offer my president is my detachment as a professional." I'm sympathetic, but I'm like your doctor who may love you but has to be detached for advice. So if that holds all the way to the presidential desk, then do you see with the detachment that if the advice is right, the president knows what the parameters are. And for that choice, the available menu of choices is usually pretty wide. It's that last mile that matters. Should we do one or two? About? Okay. Chris? Yay, a faculty member. Now we are complete.
I just was sitting here wondering, we're about to go into an election, and I think the youngest person that is sort of running is in his mid-40s, and the oldest is in his early 70s. Have you ever noticed in your examination of the success or failure of presidents in faithfully executing the law any age correlation that cuts one way or another?
I don't think so. I don't think so. I suppose it does bear on the personality and character matters I mentioned. It was said of Teddy Roosevelt by a friend, you have to remember the president is only about 6. So there's an age criterion for you. Ronald Reagan famously said that he always liked to think about Jefferson because after all he knew him. No, I don't think age, you know, let me talk about elections with regard to this. When I want to look at a candidate for a presidential election, what I want to know is the things that I've been talking about here. What is the person's character? What's their personality? What are their broadest gauge political values? What's their experience? What are they informed by? Those kinds, I don't want to know what's in the policy papers. They'll throw those away the second they're elected. So it's those primal matters, and I don't think those vary very much by age. It never leapt out at me. It's a very interesting question, Chris. So let's do a final one. This has to be a student according to our protocol. So all of you know I will call on you if you don't. In the way back. Larry. Thank you, Larry. You sit in the way back in class, too.
I'm learning. You close with discussing Lincoln and how he's kept, you know, kind of our better promises. And I think you make it clear that the Constitution provides a common source of authority and limit. And I wonder if there's also a common aspirational wellspring. Where do these better promises come from, and are they common among all the presidents?
You know, Larry, what interests me most, I think, about presidential rhetoric in these very large frames is the presidents who have reconstructed American politics, Jefferson, Jackson, Lincoln, FDR, Reagan, have, without exception, reached back to values of the founding and tried to invoke those. So what they have not done was to have said, we need a brave new world. Uniformly, what they've done is said, we need to return to the most rock solid of our original values, and here's my interpretation of those. So that's the link that you always see. And guess what? You will see all the presidential candidates from both parties parading that one in various ways. Well, maybe we should listen to what they seem to be invoking. Of course, they're trying to tie themselves to the grandeur of the Constitution as they see it and as most Americans see it. But that's what they appeal to, and they don't admit they're heading as far onto untrodden ground as often they are. I think we're done. Why don't we have a party? Thank you. Great.